Hi guys, welcome back to the channel. This is the House of Law and it's me again, Attorney Al Jumrani. This is part 4 of the series entitled Is the Law Biased? As promised in the last video, for this video, let's talk about the bias in commercial law. Let's begin. Kung hindi nyo napanood ang part 3, mapapanood nyo ito by clicking here or by clicking the link in the description box below. So in part 3, I explained the bias in criminal law in favor of the accused. I gave different instances when the law sides with the accused, putting therefore the burden on police officers and the prosecution to prove that the crime was committed and the proper procedure was followed. I also balanced that when I showed you the instances when the law is skeptical, ibig sabihin not so accused friendly, no? And the accused has the burden of proving a defense. I really hope you found that video helpful. Now, for today's video, let's talk about and look at the bias in commercial law. So first, let's define commercial law. Commercial law, also known as trade law or mercantile law, is a body of law that deals with regulating the conduct of businesses that engage in merchandising and commerce. It is a broad area of law that includes corporation law, insurance law, intellectual property law, banking law, and transportation law. So let's first look at constitutional provisions that relate to business and trade. Now, bear with me because some of these provisions are a mouthful, starting with Article 12, Section 1 of the 1987 Constitution. The goals of the national economy are a more equitable distribution of opportunities, income, and wealth, a sustained increase in the amount of goods and services produced by the nation for the benefit of the people, and an expanding productivity as the key to raising the quality of life for all, especially the underprivileged. The state shall promote industrialization and full employment based on sound agricultural development and agrarian reform through industries that make full and efficient use of human and natural resources and which are competitive in both domestic and foreign markets. However, the state shall protect Filipino enterprises against unfair foreign competition and trade practices. In the pursuit of these goals, all sectors of the economy and all regions of the country shall be given optimum opportunity to develop. Private enterprises, including corporation, cooperative, and similar collective organizations, shall be encouraged to broaden the base of their ownership. Okay, ang kasunod naman ay Article 12, Section 13 of the 1987 Constitution. The state shall pursue a trade policy that serves the general welfare and utilizes all forms and arrangements of exchange on the basis of equality and reciprocity. Next would be Article 12, Section 19 of the 1987 Constitution. The state shall regulate or prohibit monopolies when the public interest so requires. No combinations in restraint of trade or unfair competition shall be allowed. Next, Article 16, Section 9 of the 1987 Constitution. The state shall protect consumers from trade malpractices and from substandard or hazardous products. So from the foregoing constitutional provisions, it is obvious that the state prioritizes business and trade by promoting support for private enterprises, including corporations, cooperatives, and similar collective organizations. Kinikilala na malaking tulong sa paglago ng ekonomiya at pag-unlad ng bansa ang pribadong negosyo at komersyo. Gayunpaman, may limitasyon. The Constitution provides that trade must serve the general welfare. Consumers, you and I, must be protected from trade malpractices and substandard or hazardous products, and monopolies and combinations in restraint of trade, and that which result in unfair competition shall not be allowed. Consistent with these constitutional provisions, existing laws and rules and settled jurisprudence, here are some of the presumptions and rules of interpretation in commercial law. Una, in insurance law, in the interpretation of insurance policies, whose side is the law on? Answer, the insured. In case of doubt or ambiguity in an insurance policy, the doubt is to be resolved against the insurer and in favor of the insured. American Home Assurance versus Tantuco Enterprises, GR number 138941, October 8, 2001. Thus, if an insurer denies a claim on the ground of some obscure provision in the policy, said obscurity will be resolved against the insurer and the claim will be granted in favor of the insured. The reason is that a contract of insurance is a contract of adhesion. Any ambiguity in a contract of adhesion is construed strictly against the party that prepared it, meaning the insurer. Loyola Life versus ATR Professional Life, GR number 228402, August 26, 2020. By the way, a contract of adhesion is one in which one of the parties imposes a ready-made form of contract where or which the other party may accept or reject, but which the latter cannot modify. One party prepares the stipulation in the contract while the other party merely affixes his signature or his adhesion thereto, giving no room for negotiation and depriving the latter of the opportunity to bargain on equal footing. Saludo versus Security Bank, GR number 184041, October 13, 2010. Next, in banking law, in case of a forged endorsement of a check and the check was encashed, who is presumed negligent? Answer, the collecting bank. How about if the signature of the drawer of the check is forged, for which reason the check was encashed? Who is presumed negligent? Answer, the drawee bank. Reason, these banks ought to know the identity, including the signatures of their depositors. Associated Bank versus Court of Appeals, GR number 107382, January 31, 1996. Isa pa, in banking law, in case of mortgages made in favor of banks and a third person turns out to have a better right to that mortgaged property, who shall suffer the loss? Answer, the bank. A banking institution is expected to exercise due diligence before entering into a mortgage contract. The ascertainment of the status or condition of a property offered to the bank as security for a loan must be a standard and indispensable part of its operations. Arguelles versus Malarayat Rural Bank, GR number 200468, March 19, 2014. Now, another rule in banking law. In case of unauthorized withdrawal or loss of depositor's money, who is liable? Sagot, the bank. The depositor expects the bank to treat his account with utmost fidelity, whether such accounts consists only of a few hundred pesos or of millions of pesos. Gross negligence of a bank in the handling of its client's deposit amounts to bad faith that calls for an award of moral damages. Kagungun versus Planters Development Bank, GR number 158674, October 17, 2005. Now let's move to transportation law. In case of damage to or loss of goods or death of passengers, who is presumed negligent? Answer, the common carrier. Common carriers are presumed to have been at fault or to have acted negligently if the goods are lost, destroyed, or deteriorated. Bascos versus Court of Appeals, GR number 101089, April 7, 1993. Furthermore, in case of death of or injuries to passengers, the law presumes said common carriers to be at fault or to have acted negligently. Pilapil versus Court of Appeals, GR number 52159, December 22, 1989. Now, in corporation law, if there is doubt as to the validity of a corporate act which on its face is within the corporation's powers or purposes, whose side is the law on? Answer, the corporation. Corporations are presumed to contract within their powers. This presumption can only be rebutted by convincing evidence that the act is ultra vires. University of Mindanao versus Bangko Sentral ng Pilipinas, GR number 194964-65, January 11, 2016. At yan po ang ilan sa mga presumptions o biases in commercial law. These presumptions or biases only offer a preliminary evidence. They can be rebutted. But as shown by some of the cases earlier cited, the presumption is in favor of business. The responsible kind of business, of course. Kaya hindi pwedeng naagabyado ang publiko. When business is done to the prejudice of the public, then the court imposes a bias against the business, and the business has the burden of proving compliance and observance of the standards of diligence required by law. At dyan po nagtatapos ang part 4 ng seryeng ito na pinamagatang Is the Law Biased? Watch out for my part 5, wherein I will discuss civil law, my favorite. So in the meantime, if you like this video, please give it a thumbs up. If you haven't subscribed yet, ano pa hinihintay nyo? Please subscribe and click the notification bell so that you will be alerted when I upload my next video. See you soon mga Cows of Law. Laging tatandaan, isip ay buksan, alamin ang batas. Bye guys!